Good evening, everybody. This is the Beyond the Code podcast. I'm here with Ruairi and today we're talking about IP and software. Ruairi, what's the first thing today?
So thanks for having me, Eddie. Today I'm here to talk about intellectual property in software. I suppose an overview at the start. We'll go over a few of the kind of components that we'll be talking about today involved in IP. So first of all, copyright. Everyone's heard of it before, I'm sure. But specifically, copyright safeguards the specific expression of an idea, protecting the actual, in terms of software, source code and visual interface from any unauthorized reproductions. Then the next thing we'll be talking about is patents, which grant exclusive rights to the functional aspects of an invention, protecting novel algorithms, methods, or systems regarding how the actual code is written. Yeah, and then trade secrets encompass confidential business information such as back-end logic or data sets that derive independent economic value specifically from being unknown to the public so that other companies or people can't use those secret algorithms. Or
I'd be interested to know like what the trade secrets in software would be, because obvious ones in real life would be like the Coca-Cola formula where like only two people need to know it, to an extent where two of them can't even be on the same plane together. So I'm interested in that.
Yeah, so I suppose the best way to learn about that is to jump into some of our case studies that we have.
Yeah, fire away.
So the first one is the infamous battle between Oracle and Google. This wrapped up in 2021, kicked off in 2020. So when Google were building Android, they wanted developers to feel at home. So they used the structure and names of 37 Java APIs, which Java was owned, or it still is owned by Oracle.
Yeah.
But they wrote their own implementation code.
Okay.
So Oracle sued, claiming that the structure and organization of the APIs were copyrightable works. So this being the method names, the arguments, and the hierarchy of these APIs. So if Oracle had won this case, this would have been massive, caused massive issues in software, because you can imagine anyone writing code for different APIs. One of the key things in software is having code that's readable. And if you're limited by not being able to use similar API structures and names, you're in big problems, because the amount of names that you can go through shrinks.
I was going to say the first thing that comes to mind there is just it doesn't sound sustainable whatsoever. Like imagine if a shop or its naming conventions or the processes it used wasn't be able to be replicated anywhere else. It just wouldn't work.
Yeah, so it would have caused massive issues, making systems being interoperable a licensed privilege, which means that in this case, Oracle or whoever owns these copyrightable API structures would be able to make money off developers using the same structures and making them able to work with these systems.
If how would that work if someone used that system or that structure? Would they have to pay a subscription, or
they would have to pay some sort of licensing fee,
Okay.
similar to if you wanted to use some other form of legally copyrighted work in your whatever it is that you're making or building. So this, especially in software, there's a community and a kind of culture of open source and open standards.
Yeah.
And had this gone through and set precedent, it would have completely put that into jeopardy.
Yeah.
For the developer to do it themselves, because they may find themselves into some legal trouble. And, so many technologies rely on re-implementing APIs. So if this ruling had gone in favor of Oracle, which it didn't, it would have resulted in huge uncertainty for nearly every piece of software.
Yeah.
So it would have expanded copyright to cover ideas and functionality, not just code. So the idea of, say, having, in the simplest terms, an API method for getting something from a database. If that was, these APIs were a bit more complicated than that. But in general terms, having the parameters and the naming structure of that would just if someone else had copyrighted that before, you wouldn't be allowed to do that without licensing.
It would also be difficult to draw a line. Like, how specific do you get? How general are they allowed to be? Would you get to a stage where you wouldn't be able to use just a simple get API?
Yeah.
Like if it went down a rabbit hole like that, you know?
Yeah. So thankfully, Oracle didn't win this case, and, you know, Google were allowed to do this. An example that I have here is that creating an AWS S3 compatible API would have become legally dangerous. So, you know, it's just another thing of things that are used so often and so frequently without very much thought into, you know, oh, has someone else done this before?
Yeah.
Or who owns this? Which is, you know, in the minds of software engineers, that's not really something that comes in to your head when you're writing something like this, like an API, because, you know, normally they're written for other developers to use, for your own use, and the kind of open standard is protected in that way, as we saw in this case. So to really put it into context, what could have happened is if Oracle had won, Linux would not legally be able to copy the Unix API structure, so which is behind nearly the entire operating system.
Yeah.
So this operating system, Linux, which is used, you know, by so many people, especially developers, seen as one of the best, might not even be able to exist legally because it uses and re-implements APIs from Unix. So what happened as a result, after 11 years of litigation, the Supreme Court ruled in favor of Google, saying that the API was fair use because it allowed for new creative platforms, for example, Android, to exist. So, you know, this is something that not having these copyrightable and not allowing companies to, you know, charge licensing fees or copyright API structures shows that it allows for innovation, especially in tech. So this ruling wasn't exactly clear cut, as the Supreme Court didn't decide if APIs are copyrightable, but they ruled that even if they were copyrightable, Google's use of the Java API structure was fair use. So not exactly concrete on their ruling.
So there is some cases where people could be legally liable.
Yeah.
If they had an API that was exactly.
Possibly. Something.
It would have to be something like very like large though. Like that would have to be ripped off straight from the source.
I think that, I suppose the fact that this went on for 11 years and was most likely very costly for both companies, although both companies obviously saw value in seeing it out because, you know, Google saw value in being able to protect the product that they made and not have to pay licensing fees. Oracle obviously saw value in being able to possibly gain some sort of fee from their method or their API structure.
And even what we were saying before, maybe Google might have felt a bit of a social obligation to not let this become a new norm.
Yeah, definitely. So it's unclear, as a lot of these legal situations are, which I suppose is kind of why we're talking about this, to try and make it a bit more clear, but it's unclear as to what exactly would constitute unfair use and copyrightable APIs.
Yeah.
But in this case, it was deemed fair.
So that's a great story, Ruairi. I want our listeners at home to consider this case and the decisions made by Google at the time. Do you think they were right to replicate the API method headers? Were they correct that it should be copyrightable or at the least fair use? Let us know down in the comments below. Okay, everybody, we're going to do a different section on the podcast today. A trivia question for you based off that case study that Ruairi was talking about. So the question is, if the Supreme Court had ruled in favor of Oracle, what well-known operating system could have been affected or never existed? So write that question down and we'll give you the answer at the end of the podcast. Okay, Ruairi, that case study was about copyright in software engineering. So tell me about trade secrets in software engineering.
Yeah, so there's an interesting story about Waymo and Uber, particularly concerning one developer who was an engineer at Google's self-driving division, Waymo. You might have heard about them driving about kind of in California, the self-driving cars recently. This happened in 2017. So he left Waymo and Google subsequently in January of 2016 to found his own self-driving truck company called Otto. So Otto focused on fitting semi-trucks with radars, cameras and laser sensors for self-driving purposes, and was trying to commercialize this company and commercialize self-driving more than I suppose he thought that Waymo was doing, which is why he left and founded his own company. And nearly immediately, Uber acquired Otto, his company, for $680 million.
Wow.
So,
pretty penny.
Yeah. So what kind of happened before he resigned at Google was that Anthony Lewandowski downloaded around 14,000 confidential internal files, about 10 gigabytes of data, which, you know, even
doesn't
without
exactly
having
sound
to,
legal.
Yeah, without having to know too much about IP, I don't think that that's a smart idea to be doing. So these files were blueprints for Waymo's LiDAR circuitry, design files, and testing docs. Then he put these onto a personal drive, wiped his laptop, and brought them to Otto, his own company, and then later Uber.
So he's essentially just sold all these trade secrets to Uber,
Yeah.
even though it was started from his own company. Like he got 600 million because that was the value in the company.
Yeah, the value in the company seems to be, as the result we'll talk about later, the results of the suit. But the value of the company was mainly the trade secrets
that
of
he'd gotten
Waymo.
from Google.
Yes.
Yeah. Okay.
So in February in 2017, Waymo sued Uber for IP theft. Google were originally reluctant to pursue the case, but their hand was kind of forced when a supplier to Waymo showed a Waymo engineer a copy of a schematic of Uber's LiDAR design. And then it was
Very
clear that the design was almost identical to Waymo's design. So the case got settled in 2018. Uber agreed to pay Waymo $245 million in equity to settle the suit, and they agreed not to use the technology. Lewandowski got fired, sued into bankruptcy, and criminally charged by the US Department of Justice.
Okay.
So overlying ethical failures that Anthony Lewandowski committed were exfiltrating trade secrets as opposed to just remembering things from his previous employment with Google, which is a lot more difficult to prove, IP infringement if there's not 14,000 files that got wiped from a laptop.
It's also arguable as well that like there probably is only a few ways to do like what he was trying to do correctly with the LiDAR sensors and stuff. So that's definitely in the bracket of experience, in my opinion. Like that's why you would hire someone in the field. Like technically you are getting like trade secrets by hiring people who are very informed and who've done this before. So
yeah, and I suppose that's on Uber, especially the leadership. Travis Kalanick at the time was accused of ignoring glaring red flags about the source of the intellectual property that they got from Otto. They were so desperate to catch up in this kind of race in the field that I suppose they didn't care, which is on them, and they paid the price for it, quite literally. They spent $680 million acquiring the company. They had to pay about $250 million back to Google, and they aren't allowed to use that technology.
I think that's very justified. Like I think someone knew what was going on there, whether it be the whole company or some people higher up. Okay, and on to our trivia question for that case study, if you were listening. Can you name two types of data that Lewandowski stole that were considered trade secrets? Write down your answer and I'll give you the answers at the end of the podcast. Okay, Rui, thank you so much for coming on the podcast today. You've been an absolute gent, and thank you.
Thank you for having me.
Brilliant. Okay, on to the answers of our trivia questions for today. So question 1, if the Supreme Court had ruled in favor of Oracle, what well-known operating system could have been affected or never existed? So the answer for that one is Linux. So well done if you got that. And so on to question 2, what are 2 types of data that Lewandowski stole that were considered trade secrets? So if you get 2 out of these 3, you get the answer right. So it's Waymo circuitry blueprints, design files, and testing docs. On to question 3. What famous open source projects has Copilot produced code from? And so the answer for that is Quake 3 Arena. So thanks very much for playing, and we'll see you next week. I want to thank everybody for listening to this podcast series. Any additional information about the case studies or anything we talked about will be in the description.